Hi, I'm Sean Hauser with Vicente Sederberg, and I'm here with our VS Hemp and Cannabinoids practice team attorneys and Eric Steenstra to walk through with you the USDA's interim final rules for hemp farming in the US. We are really excited to walk through these final rules with you, and we have our hemp attorneys across the country here to break them down by topic. While we understand these rules aren't perfect, it's undoubtedly progress and the framework for the next phase of this legal hemp industry. And we encourage you to remember that these rules are final rules. The USDA had to work with a number of different agencies in crafting these rules, and is wanting and interested to hear your comments on areas of improvement and areas of concern. So as you listen to the summary, start thinking about what particular aspects of the rules affect your business, where the rules can be improved so that we can work to provide reasonable solutions and feedback on the comment period. The comment period is a 60-day period. It starts October 31st, 2019, and we look forward to hearing from you to help you craft comments for USDA. Before I turn it over to the attorneys, we're honored to be joined by Eric Steenstra from Vote Hemp, the longest standing grassroots hemp advocacy organization who's been really working for over 20 years to bring back hemp farming in the US, and deserves a lot of the credit for the federal farm bills and the rules we're going to be talking about today. So a huge nod of gratitude to Eric, and I will turn it over to him.
So I'm going to talk a little bit about what the new regulations mean for the industry. We've had a few days to review them. We've worked for years to get to this point. Passage of the Farm Bill was a huge accomplishment, but it was just the beginning. And now we've got a lot of work ahead of us to make sure that this can be successful. The new USDA regulations mean the beginning of a new era where hemp is now agriculture instead of being a controlled substance. It provides much certainty to producers. We feel that USDA mostly followed the roadmap that Congress laid out, which was fairly clear and limited. However, there are some areas of concern, and meddling by the DEA and Drug Czar's office is very evident. The industry will need to work with USDA and Congress to ensure the regulations are amended to allow the US industry to operate successfully, to grow the US market, and to maintain its competitive position in the world market. To give a little background, brief background on Vote Hemp, we are a nonprofit advocacy group that was founded in 2001. Our mission was solely to bring back commercial hemp farming in the United States. We began working with members of Congress to try to get legislation introduced, and in 2005, we helped draft the first Industrial Hemp Farming Act with Representative Ron Paul. Later, we worked with Representative Ron Wyden to get the first Senate bill introduced in 2012. And we also worked with Representative Polis in 2013 on his amendment to the Farm Bill, and also with Senator McConnell's office as they worked to expand that language into what ultimately became the 2014 Farm Bill hemp provision, Section 7606. We also helped to draft and pass the 2018 Farm Bill language and ensured that tribes were included. And we worked very hard to try to remove and then limit the felon provision that was added into the bill once it reached the Senate Agriculture Committee. We've been working for decades also with states, including California, Kentucky, and a number of others on the hemp laws. So what are some of the things that the industry needs for success? One of the most important things is hemp genetics. We grew hemp in this country for centuries. And in fact, the USDA used to do research on it and develop some varieties that were good for farmers back in the 30s and 40s. However, all those genetics have been lost, and the industry has changed, and the needs of today's farmer are different than what farmers from 70 years ago were looking for. So research on genetics, development of stable hemp genetics for both fiber, for grain, for extraction and CBD, these all need to be developed, and some of that's underway, but we don't yet have everything that we need for all the different areas that want to be able to grow hemp, for the different climates and elevations, as well as for the specific types of hemp that will meet the standards that we have and also give farmers a profitable crop. We're also looking for reasonable and accurate sampling and testing requirements from the USDA. Crop insurance, there's another big one that is definitely being developed now. It's likely to be rolled out in select states in 2020. Another big area is investments in hemp processing to provide a path to market for farmers. We need to update state legislation now that this new regulations are out. There's a number of requirements that may require updates to either state legislation or regulations in order for those states to be compliant with the new Farm Bill. We need regulatory certainty from the FDA. It doesn't appear that we're going to hear from them in 2019, and it's not clear exactly how much longer we'll have to wait. But Congress is also looking at this, and we definitely need some certainty on the issue of selling extracts. The FDA has created a lot of uncertainty and gray, and we need that cleared up. Formal banking guidance would be helpful. The National Credit Union Administration recently issued some guidance, and there have been some positive steps, but there's still a lot of questions at banks as to how they do business with the industry. The USDA regulations are helping with that, but we need more. And then finally, interstate transportation. The USDA did address this as far as a legal issue, but we still could use some more guidance on how to transport that so that when a local authority inspects a shipment, they know they can tell that it's a legal shipment and not impede it from interstate commerce. So just briefly, I'm going to review the minimum requirements specified in the 2018 Farm Bill. They were pretty limited, and that was the approach we were expecting USDA to take, is just do the minimum and let the states add anything that they want. So it was to maintain information regarding the land on which hemp is produced through the licensing process, to create a procedure for testing the crop, a procedure for conducting an annual inspection that's limited to one per year by statute, procedure for the effective disposal of products that are produced in violation of the Farm Bill, a procedure to comply with enforcement procedures, and a certification that the state or tribe has the resources and personnel to carry out all the requirements. So USDA regs are out. What's good? What are some of the positive things that we see in there? Number one, we want to thank USDA for working very hard to get this done. There was a lot of work that went into these regulations, and they did it in a very short period of time, less than 9 months actually. When they first got the directive from Congress, we were going through a government shutdown, and Secretary Perdue and the staff at Agricultural Marketing Service and the other departments have worked very hard to try to get these regulations out in a timely fashion. We're really thankful for that. This helps to provide that certainty that the industry and farmers need about how hemp will be regulated going forward. I'd like to also note that while the 2018 Farm Bill is now fully in effect as of Thursday when the regulations were published, the states can continue to operate under the 2014 Farm Bill provisions for another year. So that if states need a little more time to get this figured out, they have an option to continue to operate under the older provisions of the 2014 bill. Crop insurance, as I mentioned, is coming in 2020. The USDA has mentioned whole farm revenue protection and also an FSA non-insured crop disaster assistance programs being available for hemp producers. Hemp's eligible for NRCS conservation programs. There's more on the USDA website about that. There's a new requirement for FSA acreage reporting. That's the Farm Service Agency. We think this is really important. It's critical to track the progress of the industry and to see how much hemp is being grown on any given year. So that's helpful. The USDA also interpreted the felon ban in a limited way to apply it only to licensees. So for example, if you have a farm manager or a worker that works for you, you don't have to get background checks on them. It's only the folks that are actually investors or the license holders themselves that actually have to do that. Also, hemp exports are not affected in any way by these new regulations. The USDA also reaffirmed that states cannot block interstate transportation. Probably need some additional clarification as we go forward, but this is very helpful. And I think it's a little more final than when the legislation passed. And then finally, no federal seed certification program initially. Ultimately, this may be very important and helpful for the industry, but there's a question as to whether it should be done at the federal level and how it should be done. And USDA had questions about how to go about it and wasn't sure that they could actually accomplish that initially. So they're seeking feedback on that. So what are some of the things that we don't like or that are really concerning about the new regulations? Number one, the testing requirements are very onerous. They require states and tribes to test every lot that's harvested. And unlike what we have today, where some of the states have implemented random testing program and test only portions of the crops that are out there in order to ensure compliance, they're now going to require every single lot to be tested. This is unnecessary in our opinion. Sample requirements also don't require a full homogenized whole plant sample. They did improve it somewhat over what some states have done. The top third of the plant is now sampled, the floral material from the top third of the plant, but we think that could be improved and should be as well, because the definition of the plant says it's the THC levels of the plant by weight, not just of the flowers. So also samples must be taken by a USDA approved sampling agent or a law enforcement agent. We don't know yet all the details on what that is. There is a sampling procedure that they've released. We're not sure exactly how the training is going to go or how easy it's going to be to get sampling agents up and ready for the next harvest season. And then a big concern was the distinction between negligence versus sort of an intentional when it comes to a hot crop. The USDA chose to make a cutoff at 0.5%. So essentially anybody who's found to be growing a crop that was over 0.5% could potentially be viewed as not just negligent, but criminally liable. This is clearly too low, and it's a major concern we're going to be sharing with USDA, and we're definitely gonna have to push to get that increased. The harvest has to be completed in only 15 days. We've heard feedback that that's problematic. Sometimes that's the 15 days from the time that the samples are taken. Often sampling can take at least a minimum of, the sample testing rather can take a minimum of 5 days, and we've heard quite longer in a number of states. And so the idea that you have to complete the harvest within 15 days is unreasonable. In addition to that, there's weather factors and other things that could affect that timeline. So we think USDA needs to expand that window, probably to at least 45 days, but certainly more than 15. Also, the USDA initially will do a year-round application program if for any state doesn't have its own program where people would be applying through USDA, but then later goes to only a 90-day window. And that window we don't think is sufficient to cover for cultivation that's happening in greenhouses or new people, and the timing on it doesn't allow for people that want to do it close to the season. For example, in January or February, it would be too late to apply for a license. Another problem, DEA registered lab mandate. We looked into this, and it can take 9 months or to maybe a year or more just to get registered. So if a lab doesn't already have this, that's a problem, and there's no grace period for labs to get this registration. Again, showing the signs that we don't think the USDA stuck this in here. And then the disposal of any hot hemp can only be done by a DEA approved handler of marijuana. This is a huge problem. We think this is going to be a problem for states, and it's totally unreasonable, and it was not called for in the congressional bill. So in the farm bill, it really doesn't specify that at all. So there's some silver lining that we noticed. One thing that we wanted to highlight was the measurement of uncertainty. We did note that the DEA or the USDA is requiring testing of crops and sticking straight to a hard 0.3% on the determination. And they're also using total THC and not just Delta 9. So that's going to make it difficult for a number of the varieties that are out there and available. However, the measurement of uncertainty was added. And we think that there needs to be some more focus on that, because there is essentially it's a margin of error, and there's a measurement of uncertainty can be calculated not just in the testing, but also potentially in the sampling. It may need to do some kind of a study to determine what that's going to be, and it may take some time to figure that out. But we think the measurement of uncertainty could be significant, and it could provide some flexibility on THC levels, so that hopefully if somebody comes in at 0.39 or 0.42 or whatever, that this measurement of uncertainty would still allow that crop to be within the margin of error and not get destroyed. So one of the other things I want to shift to now is to mention that Vote Hemp and Vicente Sederberg worked together to develop a model hemp production plan for states. That is out there and available for free at the American Hemp Campaign website. We included input from a number of other industry groups. We were very appreciative to get that their participation, including APA, the American Herbal Products Association, the Hemp Roundtable, the Hemp Industries Association, the National Hemp Association, and Ag Hemp Solutions. The plan we are going to work to update this now that we have the DEA regulations, but this can be very helpful for your state regulators, and we encourage everybody to check that out if they're working with state regulators and want to have something as a model to use so that they don't have to start from scratch. Finally, I want to highlight a bill that I think is an example of the kind of things that we're going to need in the future to make sure this industry continues to be successful. We've got HR 3652. This is the Hemp for Victory Act that was introduced by Representative Gabbard of Hawaii. It's kind of a kitchen sink bill. It's got a lot of different provisions in it that support different types of research that might help the industry. For example, researching whether or not hemp foods could be included in school lunches, or we're looking at so the CBD extracts and whether they might be helpful for other uses as well. So you might want to take a look at that. We're certainly looking to get people to go to votehemp.com and send in letters to their legislators and let them know they support this. And hopefully we can get legislation like this passed that will help support the industry overall. And so I'm going to go ahead and turn it back over to the good folks here at Vicente Sederberg. I want to thank them for all the work that they've been doing, and really appreciate collaborating with them on this webinar today.
Hi, my name is Michelle Bodian. I'm a senior associate out of the New York office in the Hemp Practice Group. This entire regulation is essentially about cultivation, so I'd just like to introduce a few key points before my colleagues dive into much greater detail. As you're aware, states, territories, and tribes wishing to obtain primary authority over hemp production will need to create a plan incorporating minimum requirements set out both in the 2018 Farm Bill and these new regulations. Farmers in areas without a plan are able to apply directly to USDA to obtain a hemp producer license. However, there is a catch. That state, territory, or tribe could potentially limit or prevent the cultivation of hemp altogether within that area. So it would be up to each individual states to decide whether to allow this crop to grow. If a state does have an approved plan by USDA, you as a farmer will need to apply under that program. You're not allowed to circumvent your state and go directly to USDA. You'll have to apply under that state-approved program. You see here up on the slide, whether it's a USDA or a state hemp producer application process, either way, you'll need to provide a legal description and a GPS locator. And the reason for that is in many rural areas, there are not actual physical addresses. And this also means you can only apply after you have actually identified a piece of property where you intend to cultivate hemp. There's some other basic information that's required regardless of who's administering your program, USDA or a state or tribe. You have to provide contact information, so this cannot be an anonymous application. And please do remember that all applications submitted to state and federal governments are public records, and they would be subject to a Freedom of Information Act request. These records will need to be maintained for 3 years, and states and tribes also have to report certain data directly to USDA. Under these new regulations, it's a requirement to report crop acreage directly to FSA, Farm Service Agency. This is similar to other crop reports. States and tribes will be issued a licensed or authorization number that then must match the referenced in these acreage reports. FSA is the main lending arm of USDA, so many farmers are familiar with FSA and their offices. They're in all 50 states and in most territories. This new crop acreage reporting requirement is really highlighting USDA's focus on gathering data and keeping track of where this hemp is cultivated in the US. One aspect of cultivation that's noticeably absent from these regulations is the seed certification program. Many states have created or are in the process of creating a seed certification or an authorization type program looking at germination rates and THC content. It looks like it's going to continue to be up to each individual state to create these programs. USDA cited geographic and environmental conditions as factors preventing them from creating a program. While it would have been difficult to create such a program in such a short amount of time, really it has been less than a year since the Farm Bill came out. That isn't a lot of time to create a robust program, so that is a short amount of time. It would have been better, though, had USDA at least put some money aside to research the possibility of creating such a program rather than saying they were not going to invest those resources at this time. One thing that these regulations confirm that is also in the 2018 Farm Bill, a state may adopt stricter regulations or rules or prohibit the production of hemp in that state. Again, this is only with regard to cultivation. Territories and tribes can be more stringent just with regard to production, meaning cultivation of hemp. It's too soon to tell whether any state will outright prohibit the cultivation of hemp, or instead certain states might choose to cede their authority to USDA and let USDA control the production of hemp in that area. Many states do obviously want to obtain this primary regulatory authority. This was posted on USDA's website. It's valid as of October 29th, 2019. 10 states and 10 tribes have submitted plans for review and approval. These plans, though, however, were submitted before the regulations came out. So we'll have to wait and see if any of these states intend to take back their plans, make modification, make changes, or whether USDA would be in a position to start approving these plans as is. I'm going to now hand off the baton or the hemp stock to Corey to kind of discuss a little bit more detail about sampling.
Thanks, Michelle. My name is Corey Cox. I'm an associate in the VS Denver office, and today I'll be talking about sampling and hot hemp and enforcement. And so sampling is the process by which hemp is selected and collected for testing. So today I'm going to walk through the who, what, when, where, and why of of sampling. And so the who of sampling is the basically sample collectors. And under the USDA rules, these are basically going to be third-party sample collectors. These could be federal, state, local, or tribal law enforcement agencies, or they can be other persons that are designated by federal, state, or tribal authorities under the state or tribal plan. So what? This is the actual sample itself. And so the sample is the inflorescent plant material. This is the flower or bud where the highest concentration of cannabinoids is located in the plant. The idea of this sample is to provide a representative sample of the entire lot, with the lot being a contiguous area where the same strain or variety of hemp is grown. The sample itself will be composed of multiple cuttings, creating a composite sample, again, representative of the entire lot. The number of the number of cuttings in a given sample is based on the number of acreage grown in a given lot. The samples or cuttings will be taken directly from random plants within the lot, with the top 1/3 of the plant where that flower or bud material is located. This floral material will then be bagged, sealed, and assigned a unique ID number that can maintain or document a chain of custody from the farm through the testing labs. The when, basically when the sample is going to be collected, is within 15 days prior to the anticipated harvest. So within 15 days of your anticipated harvest, you have to notify of these third-party sampling providers so they can come collect samples in your fields. The USDA rules note that this 15-day period is intended to provide the truest measurement of the THC content at the point of harvest. At the same time, the USDA felt this 15-day period was a reasonable time that could account for variables caused by rain or equipment failure, and was also a reasonable time for a farmer to harvest the entire field. Importantly, you cannot harvest prior to sample collection. And so every single lot must be tested, must be sampled, and then tested before it can be harvested and introduced into the stream of commerce. The where, basically where are these samples collected? Well, they're going to be taken directly from the lot on site in your registered area. And the person responsible for the registered area must provide these sample collectors with complete and unrestricted access to the registered area during business hours, including all kind of outdoor locations, buildings, equipment that are used as part of the cultivation process. And the why do we care about sampling? It's because the whole purpose is to ensure that the cannabis being grown and harvested does not exceed the acceptable hemp THC threshold. And that's 0.3% on a dry weight basis. And so basically any hemp that has above that 0.3% level cannot be introduced into the stream of commerce. And so what are some kind of potential implications of these new sampling procedures? There's potential this could result in greater testing costs. Right now, many sampling is done on a kind of random basis. This for mandatory sample collection of each lot could result in greater testing costs for cultivators. There's also potential this could result in testing bottlenecks, depending on the types of sample collectors that are authorized pursuant to state or tribal plans and how available those designated collectors are, especially during kind of peak harvest season. This could also impact the submission of state and tribal plans. Depending on what the laws or regulations currently say with respect to sample collection, there's a potential that regulations or even laws will need to be revised to conform with the USDA requirements. So what are some of the opportunities for change as part of this process? We're not entirely locked into this model yet. The USDA notes they will consider alternative sampling protocols as part of state or tribal plans, so long as those alternative sampling protocols are comparable to the kind of who, what, when, where, why we just outlined. And then I think the USDA is specifically soliciting public comments on this 15-day pre-harvest window in which samples must be collected. If you are cultivating hemp or plan to cultivate hemp and feel like this 15-day window is unreasonable or really incompatible with your business operations, I think this is an important opportunity to make your voice heard and to present those concerns to the USDA. So next, talk about kind of hot hemp and enforcement in the event your hemp exceeds that 0.3% threshold. And so that essentially is what hot hemp is. It's hemp with the THC concentration above 0.3% as measured on a dry weight basis. And under these USDA rules, that hot hemp is considered marijuana under the Controlled Substances Act. It is a Schedule I controlled substance and must be treated as such. And so if your hemp tests hot, what can you do with it? Well, not much. Really, you must destroy that hot hemp in accordance with DEA regulations. Again, the idea is that hot hemp is marijuana and it must be destroyed as such. As a result, there's no opportunities for remediation or alternative methods of destruction. That hemp cannot enter the stream of commerce. And so who's actually going to be responsible for disposing that hot hemp? Well, it needs to be parties that are authorized under the Controlled Substances Act and DEA regulations to control and dispose of controlled substances. And so these could be reverse distributors that are registered with the DEA, or it could be duly authorized federal, state, or local law enforcement authorities. And then there's two types of violations under the USDA rules. There are negligent violations and then culpable violations. And so these negligent violations are violations where the licensed party has a failure to exercise care of a reasonably prudent person. And so examples of these negligent violations include failure to secure a required registration, failure to provide a legal description of your registered land area, or hot hemp. The exception here is if your hot hemp tests below 0.5% THC on a dry weight basis. The USDA basically considered the multitude of variables that can impact potency in the hemp plant and determined even if a reasonable level of care was exercised during cultivation, it's still possible to have hemp with a THC level up to 0.5%. So hot hemp between that 0.3% and 0.5% still needs to be destroyed, but it's not a negligent violation to be within that range. If the USDA or applicable state or tribal authority determines a registrant has committed a negligent violation, there's corrective actions that the responsible party must perform. And so they'll be issued a corrective action plan that details basically specified corrective actions, a completion date, and certain reporting requirements. And if you fail to follow the corrective action plan, including the reporting requirements, there's potential for additional sanctions. In comparison, we have culpable violations. And these are violations that are made intentionally, knowingly, willfully, or recklessly. And if the state or tribal authority or the USDA believes that a licensee under the program commits a culpable violation, then the state or tribal authority or the USDA is directed to immediately report that violation to the United States Attorney General and the chief law enforcement officer within that jurisdiction. There's usually no opportunity for corrective action plans, and that Attorney General and Chief Law Enforcement will really dictate, Chief Law Enforcement Officer, will really dictate what happens next. So next, Courtney is going to discuss testing and how that works in relation to the sampling.
Hi, my name is Courtney Barnes. I'm an associate attorney in the Hemp and Cannabinoid Practice Group. And as Corey just mentioned, I'm going to cover testing. The 2018 Farm Bill mandates that state and tribal hemp production plans include procedures for testing delta-9 tetrahydrocannabinol. Today, I'm going to cover important terms to know, requirements applicable to testing laboratories, the USDA's proposed laboratory approval program, testing methods, how laboratories will determine compliance, and lastly, selecting laboratories, reporting test results, and fees. Important terms to know. We're going to cover these terms as they come up in the following slides, but for purposes of complying with the USDA's hemp testing rules, you'll want to understand how the rules define cannabis, decarboxylated and post-decarboxylation, delta-9 tetrahydrocannabinol, dry weight basis, gas chromatography, high-performance liquid chromatography, measurement of uncertainty, and acceptable hemp THC level. Requirements applicable to cannabis testing laboratories. So first, let's talk about the definition of cannabis. As defined in the USDA interim rules, cannabis refers to any form of the plant where the delta-9 tetrahydrocannabinol concentration on a dry weight basis has not yet been determined. This term is important in describing regulations that apply to plant production, sampling, or handling prior to determining THC content. Although cannabis has become the preferred term over marijuana, for purposes of the USDA interim rule, cannabis technically encompasses both hemp and marijuana. So let's talk about the requirements applicable to these cannabis testing laboratories. The USDA requires that all hemp testing labs be DEA registered to conduct chemical analysis of controlled substances. This makes sense given that there's a high likelihood that these labs will be in possession of a controlled substance at some point in the execution of their responsibilities. The USDA will post instructions for obtaining DEA registration for laboratories on its website. Notably, however, the USDA interim rule does not require labs to be ISO 17025 certified. The USDA notes in its guidance that it strongly recommends that labs follow ISO standards, but the interim rule as currently drafted does not require the certification. ISO stands for the International Organization for Standardization. ISO 17025 is the primary international standard for both testing and calibration laboratories. It specifies the general laboratory requirements for the competence to carry out tests and or calibrations. And this makes sense why many states required that labs be ISO certified. And so it may not have a significant impact from a practical standpoint, but from an industry standpoint, you would want to make sure that your lab follows these standards in order to have the best chance that the results they are providing are accurate. Another interesting point to note is that DEA does not require that a lab be accredited to be registered to handle narcotics. We'll discuss this in a bit more in the USDA's hemp testing proposal program on the next slide, excuse me. So lastly, there are several broad scope testing standards that the USDA requires all testing labs to abide by to ensure validity, consistency, and reliability. Quality assurance must ensure accurate analytical performance. Analytical methods selected must be appropriate for the test being conducted, and the lab must be able to successfully perform such testing. Method performance specifications must ensure that analytical tests are sufficiently sensitive for the purposes of USDA detectability requirements, the 0.03%. The USDA guidance further provides that laboratories should meet the Association of Official Analytical Chemists, or AOAC, International Standard Method Performance requirements for selecting an appropriate method. In the USDA guidance, it proposes and is accepting public comment on potentially requiring that cannabis testing labs be approved by the USDA. USDA approved laboratories would be Agricultural Marketing Services, AMS certified, Laboratory Approval Services, LAS, which administers the Laboratory Approval Program certified, and they would also have to comply with the Laboratory Approval Program requirements, general policies, and procedures. Under this proposal, an individual program for hemp would be developed under the LIP with a set of documented requirements to capture specific regulatory, legal, quality assurance, and quality control testing elements. The USDA is kind of recommending that people submit public comment on whether to incorporate this requirement or to implement this proposal, because in its perspective, they believe that the LIP would give the USDA proper oversight over laboratories doing the testing and provide quality assurance and control procedures that ensure validated and qualified analysis, as well as defensible data. If the USDA establishes this approval process, it will post a list of laboratories that are USDA approved and DEA registered on its website. The LIP would provide a way for the USDA to accredit that a laboratory can perform to a standard level of quality. And as I just mentioned, the USDA is taking public comment on whether to incorporate this into the subsequent final rule. So if anyone is interested in providing public comment on this, we would be happy to assist with that. In the alternative, the USDA is considering whether to require all laboratories just be ISO 17025 certified or accredited. They are also accepting public comment to learn about the number of labs that are accredited, the associated burden of becoming accredited, and the benefit of imposing such a requirement. Testing methods. The 2018 Farm Bill requires that cannabis be tested for THC concentration levels using post-decarboxylation or similarly reliable methods that are approved by the Secretary. Post-decarboxylation means testing methodologies for THC concentration levels in hemp, where the total potential delta-9 THC concentration, derived from the sum of THC and THCA content, is determined and reported on a dry weight basis. The term decarboxylated refers to the completion of the chemical reaction that converts THC acid, THCA, into delta-9 THC, the intoxicating component of the cannabis plant. This term is sort of the precursor to the term post-decarboxylation, which is the 2018 Farm Bill's mandate over cannabis testing methodologies to identify THC concentration levels. Total delta-9 THC concentration must be determined and reported on a dry weight basis. So delta-9 tetrahydrocannabinol, as defined in the USDA interim rules, is also used interchangeably with THC. And this makes sense because the measurement has got to encompass the total THC content using once the THCA has been converted into THC. So delta-9 THC and the term THC are used interchangeably throughout these rules. Dry weight basis refers to a method of determining the percentage of a chemical in a substance after removing the moisture from the substance. The percentage of THC on a dry weight basis means the percentage of THC by weight in a cannabis item, which encompasses plants, extracts, or another derivative, after excluding moisture from the item. As currently included in the interim rules, the USDA's approved methodologies for determining THC content are gas chromatography and high-performance liquid chromatography. Both of these are a scientific method used in analytical chemistry to separate, detect, and quantify each component in a mixture. Gas chromatography relies on the use of heat for separating and analyzing compounds that can be vaporized without decomposition. And as I noted, GC is one of the valid methods by which laboratories may test for THC concentration levels. High-performance liquid chromatography relies on a pump to pass to a pressurized liquid solvent containing the sample mixture through a column filled with a solid absorbent material to separate and analyze compounds. HPLC is also one of the valid methods by which a laboratory may test THC concentration levels. Alternative testing protocols may be requested of and approved by the USDA in writing. However, you can't just use any testing method you'd like. You would need to get, if you're going to use a method other than gas chromatography or high performance liquid chromatography or ultra performance liquid chromatography, you would need to submit a request to the USDA in writing and then have the USDA approve that request in writing before you could use that alternative testing method. Determining compliance or non-compliance. The interim rules require that laboratories calculate and include the measurement of uncertainty when they report THC test results. As a result, hemp producers must utilize laboratories that use appropriate validated methods and procedures for all testing activities and who have also evaluate the measurement of uncertainty. The interim rule defines measurement of uncertainty as the parameter associated with the result of a measurement that characterizes the dispersion of the values that could reasonably be attributed to the particular quantity subject to measurement. So the measurement of certainty is similar to a margin of error. When the measurement of uncertainty, normally expressed as a plus/minus sign with a number, e.g., for example, plus minus 0.05, is combined with the reported measurement, it produces a range, and the actual measurement has a known probability of falling within that range at typically 95%. So the interim rule requires that laboratories report the measurement of uncertainty as part of any hemp test result. The rule also includes a definition of acceptable hemp THC level to account for the uncertainty in test results. The USDA notes that the reported THC concentration level of a sample may not always be the actual concentration level of the sample. So that's why they define the acceptable hemp THC level. And this means the application of the measurement of uncertainty to the reported delta-9 THC content on a dry weight basis, producing a distribution or range that includes 0.3% or less. So this describes how plans must account for uncertainty in test results in their treatment of cannabis. If 0.3% is in the distribution or range, the sample will be considered hemp for the purposes of compliance with the requirements of a state, tribal, or USDA hemp plan. So for an example, if a laboratory reports a result as 0.35% with a measurement of uncertainty of plus or minus 0.06%, the distribution or range would be 0.29 to 0.41. And you can see how this works. 0.35 minus 0.06 equals 0.29. Because 0.3 is within that range, the sample and the lot it represents is considered hemp for the purposes of USDA plan compliance. As an example of a non-compliant range, let's say the laboratory reports 0.35% again, but the measurement of uncertainty is 0.02%. The distribution range in this scenario is 0.033 to 0.37. Because 0.3 is not within that range, the sample would not be considered hemp for purposes of USDA plan compliance, and the lot it represents will be subject to disposal, as Corey just covered. The USDA stresses in providing this kind of measurement of uncertainty and acceptable hemp THC level that this does not alter federal law with regard to the definition of hemp or marijuana. So this is important to note. Even though the USDA and state hemp plans will be using this standard to test, and they will incorporate the measurement of uncertainty in the test results for determining compliance, law enforcement may not necessarily do that. So you want to be careful, especially when you're transporting, until we understand how this will play out. It does not affect the definition of hemp or marijuana under federal law. It's a hard 0.03% at the federal level for CSA purposes. Selecting, reporting, and fees. Pursuant to USDA interim rules, the licensed producer must select the DEA registered lab that will conduct the testing. Labs performing THC testing for hemp or cannabis are required to share test results with the licensed producer and the USDA. The USDA will provide instructions to approved labs on how to submit results to them. Labs are permitted to submit to the producer the results however they see appropriate. However, the licensee must be able to print or access those results in a preferably electronic format or readily accessible format so that they can use them to prove compliance or certify that their hemp is in fact hemp. If the results of a test are conclusively higher than the acceptable hemp THC level, the lab must promptly notify the producer and the USDA or its authorized agent. Fees. The licensed producer is responsible for paying any fees associated with sampling, testing, as well as retesting. While we believe there will be variation at the state level as to what these fees exactly are, at the federal level, the licensed producer is responsible for ensuring that all of these fees are paid for and ensuring that the lab reports the results to the USDA and the other appropriate government body as required. So that's my overview of testing. Jen is going to take over with licensing and the felony ban.
Thank you, Courtney. My name is Jennifer Cabrera, and I am counsel in the New York office of Vicente Sederberg. And there's my picture. And I'll be speaking about the felony ban and licensing requirements under the USDA plan. Now, as discussed by my colleagues, hemp may be grown pursuant to a state or tribal plan. A state or tribe must submit a hemp cultivation plan to the USDA, which will then approve or disapprove the plan within 60 days. But what about prospective growers that are in states or tribes that haven't submitted a plan? So long as the state or tribe doesn't expressly prohibit it, producers in those states can apply directly to the USDA for a hemp production license. For the next few slides, I'll be talking about the licensing requirements under the USDA hemp production plan, as well as the scope of the felony ban that applies to those prospective growers. The USDA will start accepting applications within 30 days of the effective date of the plan, so by November 30th, 2019. In the supplemental information to the USDA rules, it's explained that this delay is to allow states and tribes to submit their plans, so that if producers can go through a state or tribal plan, that's preferable, and they'll do so. USDA is not going to issue licenses directly to producers that are in states or tribes that have submitted plans. So if a state plan is approved, then producers in that jurisdiction will have to go through that plan. If a state or tribal plan is rejected, however, producers will have the opportunity to apply directly to the USDA for a license. So, for example, if you're from Pennsylvania, which submitted a plan earlier this year, the USDA is not going to grant you a production license. Instead, you're going to have to wait to see whether or not Pennsylvania's state plan is approved or rejected. If it is approved, then you'll need to apply through Pennsylvania's plan. So the USDA is going to accept applications on a rolling basis for the first year after implementation, starting November 30th, when the first applications will be accepted, running through October 31st, 2020. Producer license applications can be submitted at any time during that 11-month period. In subsequent years, however, there will be an application window that runs from August 1st until October 31st. So that means after October 2020, the application window will close until August of 2021. The reason for this timing is intended to coincide with the hemp harvest for hemp that's grown indoors, when the USDA anticipates that farmers are ready to start planning for the next growing season. The USDA is accepting comments on whether that time frame is sufficient or whether an alternative application window would be preferable. So if that is just simply not going to work, we would suggest you get in touch with the USDA. Also, if you file an application during that window and it's rejected for being incomplete, you will have the opportunity to reapply even after October 31st has gone by. Applications that are rejected for other reasons, not for reason of being incomplete, will have to be appealed. As for what goes on the application, it's the usual information. Contact details, so name, address, phone, email if you've got one. If the producer is a business entity, then you'll need the business name, the address of the principal business location, the name and title of key participants, as well as email and EIN. Also, all applicants will need to undergo a background check. This applies to both individual applicants as well as business applicants. And that would apply then to key participants at a business applicant. So, key participants, that is, of course, a defined term. The regulation defines key participant to include a sole proprietor, a partner in a partnership, or a person with executive managerial control in a corporation. Persons with executive managerial control include C-level positions, for example, Chief Executive Officer, Chief Operating Officer, Chief Financial Officer. The supplemental information to the rules, however, indicates that the definition is actually broader and includes any person with or persons with a direct or indirect financial interest in an entity that's producing hemp, including owners and partners in a partnership. In both cases, the definition does not include other non-executive management positions, for example, farm, field, or shift managers. The question of who's subject to a criminal history report is important because the rules ban any person with a state or federal felony conviction relating to a controlled substance within the last 10 years from participating in the plan or from participating in a state or tribal plan. The ban lasts for 10 years from the date of the conviction. An exception applies to a person who was lawfully growing hemp under the 2014 Farm Bill and whose conviction also occurred before December 20th, 2018. The reason for this exception is that the 2014 Farm Bill did not contain this felony ban provision. So these rules carve out an exception for farmers that have been growing hemp legally since 2014, even though they had a controlled substances conviction. It'll probably be a fairly small number of people covered by that. So the felony ban applies then obviously to anyone who has to undergo a criminal background check. For those individuals that are not subject to background checks, for example, non-management positions like field or farm managers, they would not presumably be subject to this ban. Finally, the rules indicate that licenses may not, well, they state that rules may not be sold, assigned, transferred, or otherwise disposed of. However, it's not entirely clear that that is true, considering elsewhere the rules contemplate granting a license modification if there's a sale of a business. So this is one area we're going to have to see exactly how the rule plays out in practice. In addition, each license has a 3-year term that expires on December 31st. There is no automatic renewal. Rather, renewing entities will have to submit a new license application, which is the same as the old license application. And it'll include all of the same information, new background checks for all key participants, so forth. License renewals also must be submitted within that August through October window. Finally, as I alluded to earlier, the USDA rules also contemplate license modifications when there's any change to the information that's included on an application. This includes, for example, sale of a business, or also changes to the production, handling, or storage of hemp in a new location, or a change in key participants producing under a license. Producers should notify the USDA immediately if there's any change in the information provided on the license application. The USDA will then provide guidance on where producers will submit this information on their website. Now I'm going to change focus a little bit to what's missing in the USDA rules. Covers a lot, but there are also some things that aren't discussed. So the USDA rules do contain protection for transporting hemp and hemp products across state lines. This comes directly from the 2018 Farm Bill and has been reaffirmed by the USDA General Counsel's Office. So even though states are free to prohibit hemp production within their borders, they can also prohibit hemp sales within their borders. They cannot stop the shipment of hemp on their roads or in their airspace. However, as we'll see, this interim final rule, doesn't go as far as it could. So the transport protection applies to third-party transporters, not actual license holders. In the supplemental information to the rules, the USDA states that as a result of the interstate protection provided by the Farm Bill, hemp producers will have access to nationwide markets. Well, that's the goal, but in practice, hemp producers only have access to markets that permit the sale of hemp and hemp products. While states can't prevent trucks from driving through their territory, they can close their markets to hemp producers and to hemp products. So what exactly is missing? Well, the rules expressly state that they don't affect the export of hemp. And at present, there isn't such a demand for the international export of US-grown hemp. However, USDA has indicated that if there is interest in international export of hemp in the future, it'll work with industry and federal agencies to help facilitate this process. Also missing, perhaps more importantly, are any provisions on what documentation third-party transporters should carry with them. In this regard, it would be really useful to have a uniform travel manifest that lists the origin, destination, product description, and date of transport. Transporters will need to carry this document with them and with their hemp during transport to establish that the hemp was legally grown and is indeed hemp with less than 0.3% THC. Without a standardized form of transport, we're going to see conflicting state versions. So the goal of this rule is to assist law enforcement in identifying lawfully produced hemp versus other forms of cannabis that may not be lawfully transported in interstate commerce. This goal would be more easily accomplished with a uniform manifest rather than competing state versions. So while protection for interstate transport is useful, it does not protect transporters from being pulled over by state police for transporting marijuana. It doesn't stop you from spending a night in jail, even if you'd probably be able to prove your case in court. Here, standardizing documentation would be quite helpful. Finally, there is another matter that was completely overlooked in the USDA rules, perhaps unsurprisingly, which is processing and extraction. As the rules even acknowledge, most of the hemp grown in the United States is destined for CBD extraction. Yet the rules are strangely silent on acceptable methods for extracting cannabinoids, such as cannabidiol, or CBD, from the hemp plant. Now, there are various methods for extracting the desirable compounds, such as cannabinoids and terpenes, and processing those compounds into an oil. And these methods can include CO2 or an alcohol-based solvent, like ethanol or butane. Perhaps it's not so strange as while some states actually regulate CBD extraction methods, many states do not. States that require processor licenses don't actually always outline the procedures that they should use. So for the time being, the licensing and regulation of extraction or processing methods will take place at the state level to the extent it does. And now I'm going to turn it over to my colleague, Andrea.
Thank you, Jennifer. And to continue on with those areas of state authority and items that are left to the state, I'm going to talk about seed certification or the lack of a seed certification program and certificates of analysis. So under the interim final rule, producers are not required to use certified seed, and states retain the authority to require producers to plant seeds certified by a seed certifying agency. The USDA reasoning is twofold. First of all, same seeds grown in different geographical locations and growing conditions can react differently. In addition, the technology necessary to determine seed planting results in different locations is simply not advanced enough at this time to make a seed certification scheme possible. The USDA recognizes that hemp producers may take the necessary steps and precautions to produce hemp, such as using certified seed or using seed that has reliably grown compliant plants in other parts of the country, or just engaging in best practices. Another area of state authority is certificates of analysis. The interim rule simply states lots that meet the acceptable hemp THC level may enter the stream of commerce. That means that states have the ability to establish their own testing conditions for areas other than THC. States retain the authority to adopt more rigorous testing standards, to determine whether lab test reports must accompany shipment of hemp products, and to determine whether COAs or lab test reports must be reported to county or state agricultural agencies. And other than THC level, states can require testing for pesticides, heavy metals, microbials, cannabinoid content. Those are areas that are left up to the states. Acceptance starting November 30th, 2019. And I'd also like to touch on the state plan incorporation process and discuss some important dates and deadlines. The interim final rule went into effect October 31st, 2019. The interim rule is effective for 2 years, and for 60 days, the USDA will take public comment. And after taking comments into account, the USDA has 2 years to draft and publish its final rule. And October 31st, when the USDA published its final rule in the Federal Register, it began reviewing applications that were submitted prior to October 31st, 2019. If your state or tribe had submitted a plan, the USDA has 60 days from the date of publication, again, October 31st, to approve or disapprove the plan. The authority of the 2014 Farm Bill expires October 30th, 2020. That means growers can continue to grow under state pilot programs under the provisions of the 2014 Farm Bill during the 2020 planting season. In states and tribal areas that did not have pilot programs under the 2014 Farm Bill, but are in the process of developing those plans for approval, the hemp producers in those states must apply to be licensed or authorized under their state's or tribe's hemp program. And again, while a state or tribal plan is under review by the USDA, a hemp producer must apply to its state or tribe hemp program during that time period. And once a plan is approved, it will remain in effect unless it is revoked by USDA. If states or tribes make substantive revisions to their plan or to their laws, the state or tribe must resubmit within 1 calendar year from when the new state or tribal law or regulations become effective. During that time, producers will be held to the requirements of the previous plan until the amended plan is approved by USDA. If the state or tribal government does not resubmit a modified plan within the calendar year of the effective date of the change of the law or regulation, USDA will revoke its approval of the plan. Now, applying for a hemp producer license directly from USDA. If a state or tribe does not have a plan or does not intend to have a plan, a producer can apply for a USDA hemp producer license directly to the USDA. And states or tribes may use USDA plans initially and then at a later date submit their own plans for approval. License applications under the USDA production plan will begin issuing acceptance starting November 30th, 2019. If you are applying for a hemp producer license directly to the USDA, through November 29th, 2020, applications can be submitted at any time. Beginning in 2021, license applications and renewals must be submitted between October 1st and October 31st of each year. And USDA hemp producer license must be renewed every 3 years. While a state or tribal government has a plan pending USDA approval, USDA will not issue a hemp producer production license during that time. And states and tribes are encouraged to contact USDA for technical assistance in developing plan specifics. And then we'll have some final thoughts from Vicente Sederberg partner, Sean Hauser. Thank you.
Well, that sums up our high-level overview of the rules. As you know, there's a lot of nuances to these rules, and as we continue to analyze them, we really want to hear from you and your questions and comments and concerns. Remember, while these rules are effective immediately, there's room and opportunity for improvement in this comment period. And also remember that states are going to be updating and their state plans and regulations to conform with these rules. And there are a number of areas of state authority, including around transportation and processing, and in other matters, as long as they meet the minimum standard. So it's just as critical to engage with state regulators and policy makers and industry on the state level to make sure states get it right and where everyone's positioned as compliantly and successful as possible for this next chapter. And although we've reached the goal of legalizing hemp and establishing a legitimate federal framework, our work is far from done, and it's really important, more important now than ever, to engage. We're coming out of prohibition and faced with old stereotypes and misconceptions about the hemp plan, and it's really incumbent on us as the industry to educate and inform regulators, help them understand practical implications for farmers so they can make informed policy decisions, and we can have a legitimate and successful industry. So as you digest these rules, please think about the areas where your feedback can be impactful, and our team is here to support and make sure you are positioned for compliance and success in this next phase. Thanks for listening.